Jury is present, John.
Thank you, Mr. President. Good morning, ladies and gentlemen. Morning. So we are ready to proceed. Mr. Scott, Ms. Lister.
Please you go try. The state rests.
Okay. Okay, ladies and gentlemen, that concludes all the evidence that the state is going to present to you at this juncture. They certainly, in the event the defendant presents a case, which he is not required to, the state would have the opportunity to reply. So at this juncture, I have some legal matters I have to take up. So sorry to bring you in for a solid 45 seconds, but I have some things that I'm required to do at this juncture of the case. So I'm going to ask y'all to be patient with us. I don't anticipate that it'll take very long, and then we'll get moving after that. So again, please don't discuss the case. We had to do this. This is a formality. It has to be done in your presence and on the record. But we'll be right back with you as soon as we can. All right. Legal matters. I assume we have some motions from the defense.
Yes. You told me one more.
Yeah.
The defense would ask the court to consider granting the directed verdict of acquittal. Our position is at this point the state has merely raised a suspicion, speculation as to the guilt of Mr. Chow. They have failed to prove to the extent necessary that Mr. Chow acted with malice aforethought, which is the charge in the case, and we believe we have set forth a strong defense of self-defense or defense of others. Don't believe that the state has overcome beyond a reasonable doubt our defense of others, and at this point, taking a light most favorable to the state, we ask the court to consider taking the case to the jury and granting a directed verdict.
Okay. What's the state's position?
Your Honor, taking in light most favorable to the state and considering the mere existence of evidence and not the weight of it, we have presented evidence that Mr. Chow chased a 14-year-old 130 yards before shooting him in the back, which clearly shows malice and reckless disregard and extreme indifference to human life. So we ask you to deny the motion and let's proceed to the jury. Furthermore, we have disproven all 4 elements of self-defense, and they've only been inferred at this point. We have disproven all 4 already.
All right. Anything else?
Judge, just respond. Of course, this is an unusual situation because the state has a burden in 2 respects with respect to murder. One is they have to prove guilt beyond a reasonable doubt, which we believe that they have failed to do in proving malice. Second of all, they have a burden of proving beyond a reasonable doubt that he did not act in self-defense. Our position is that as far as the first element, without difficulty, Mr. Chow was not the individual. His son was the one that ran out the store. He went to protect his son. There was any connection between him and whether or not there was something taken from the store, and whether or not he was acting in a reasonable fashion. I think would fail to show that he acted or he brought on the difficulty. He was following his son to protect his son.
Well, is that, correct me if I'm wrong, and I've been working on a charge, but I understand that the without fault applies to the defendant and the person he was defending.
Judge, he has to know, though, as far as whether or not, first of all, he's without fault. It's our position.
Yeah, but it also applies to the person he's defending. They have to be without fault as well.
But he has to know that. He has to know that he would have to know that his son had some fault in the thing. When he goes out of the store, he's not thinking about the shoplifting part of it. He's thinking about where's his son going, what's going on with my son. I'm going to protect my son. I want to see what happens.
As I understand it, if his son is at fault, it's imputed to him as well.
We have to argue that, I guess, at the appropriate time when we're talking about charges, jury charges. But I understand what you're trying to say. And as far as whether or not he believed or there was imminent danger to his son of death or serious bodily harm, we think that's been established. And it's a reasonable belief, and so I think that's been established. And at that point, when he was right there and the young man was pointing the gun at his son, there was no issue of retreat. There was no way that he could retreat safely because his son was in danger at that point of being shot. And we're talking about a very serious weapon, semi-automatic pistol that was loaded, had a laser on it. So we think that the four elements of self-defense are made out, and the state has failed to overcome them beyond a reasonable doubt. So it's a kind of a unique situation because there's two issues really here about the malice, and then you have the self-defense issue.
All right, anything else to say?
No, Your Honor, there's been no testimony that he left solely to protect his son. The evidence that's been shown is they ran in tandem together. They are clearly at fault for bringing on the difficulty, screaming and yelling, chasing a 14-year-old boy. 130 yards away, there has been no testimony that he felt that he was in imminent fear of death or great bodily harm, nor did he testify or any testimony whatsoever that he felt that way about his son being in danger of death or great bodily injury. There's been no testimony whatsoever from anybody that there was no other means of avoiding the difficulty.
Okay.
Your Honor, we ask you to deny the motion. Thank you.
Anything else, Mr. Swear?
No, Your Honor, that's it. Your Honor understands my argument here, and I guess we can discuss some of that at the charge conference if you deny the motion.
Yes, sir. I'm going to respectfully deny the motion with regard to the malice. I believe it might be State versus Burdette, but that malice can be inferred or implied by the use of a deadly weapon. Although there's no longer proper to charge on that, it can certainly be considered at the direct verdict stage. As far as the defense of others, again, I've been looking at this stuff last night and this morning. At least the law appears to be that the person being defended and the defendant were without fault in bringing on the difficulty. Whether or not Mr. Chow himself was, I do find that Mr. Andy Chow was at least partially at fault in bringing on the difficulty, so I'll deny the motion on those grounds. What's next?
Judge, at this point, I know at some point you're going to have a colloquy with him as far as whether or not,
ready to go.
So I think maybe this would be an appropriate time for you to have your colloquy with him, and he's prepared to respond.
Okay. Madam Clerk, can you swear in Mr. Chow?
Yes, sir, Your Honor. Please raise your right hand. Do you swear or affirm that you shall give this court to be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
All right, if y'all want to have a seat, you're welcome to. This takes a few minutes.
It's too hard for me to get up again, so.
All right, Mr. Chow, this time I'm going to explain to you your Fifth Amendment rights. If you don't understand anything I say during our exchange, please let me know. If If you want me to explain anything in more detail, please let me know. Now, we've reached the stage of the trial where you may present your defense. You have the right to claim the protections of the Fifth Amendment to the Constitution of the United States, which states in part that no person shall be compelled in any criminal case to be a witness against himself. This means you cannot be required to testify in your case. You have the right to testify on your own behalf. However, no one can make you testify. This is a personal right, and no one can force you to testify. If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be examined and cross-examined on any relevant issue in the case. In addition, if you have any convictions involving dishonesty or false statement for crimes punishable by imprisonment for more than 1 year, and this court determines the probative value of admitting the evidence outweighs the prejudicial effect to you, the solicitor will be able to introduce your record to attach your credibility. If you decide to testify, this decision on your part must be freely, voluntarily, and intelligently made with knowledge of the protections given to you by the Fifth Amendment and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It is left entirely up to you whether or not you testify. You may talk with your attorney, your family, your friends, anyone else, but the final decision is left entirely up to you. Do you understand everything I explained to you? Do you have any questions about what I explained to you? Have you had the opportunity to discuss with your lawyers whether or not you should testify?
We have some discussions, yes.
All right, do you want to talk with them anymore? And I'm not going to ask you to make a decision right now, and I'll certainly give you some more time to you to be advised of your rights, and you certainly can talk it over with your lawyer and your family some more, and then we will address whether or not you can testify at further time.
Yes. Any more?
Thank you.
All right. What's next?
That's all I have, Your Honor.
Anything else from the state?
No, sir.
All right, Mr. Swirling, I'm assuming the defense is going to present a case?
Yes, Your Honor, here we go. My defense just walked out the door.
All right.
Now,
We'll give them a minute to round up.
okay, you might have had to go to the restroom.
Okay. I'm sorry.
Actually, both of my co-counsels are away.
All right, we'll be at ease, sir.
Jack's never done this before.
What? First trial. No problem.
I just found that out. I'm the last one to know.